B.R. Ambedkar once said, Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. Good afternoon, distinguished guests, law practitioners, and enthusiastic students of constitutional law. Welcome to our thought-provoking webinar on constitutional law in the digital age. Organized by NSS Cell of Chanakya National Law University in collaboration with the Society for Constitutional Law Discussion. I am Ishita Singh, and it is my privilege to guide you all through this intellectually stimulating session. Chanakya National Law University is one of the national law university in Patna, Bihar. It was established in 2006 by the government of Bihar as a public university dedicated to the field of legal education. The NSS cell at CNLU is a vibrant and proactive community dedicated to fostering social responsibility, community engagement, and holistic development among its students. Committed to the ideals of service and civic participation, the NSS cell organizes a wide array of activities and initiatives aimed at addressing societal issues and contributing to the welfare of the community. The Society for Constitutional Law Discussion was established by the students of Chanakya National Law University, Patna, with a vision to provide a platform for public discourse and deliberation vis-a-vis constitutional law. The Society, through its e-magazine and blog, intends to serve as a platform for students, academicians, and practitioners to engage in constitutional law discussion and writing. TSLD provides a platform where you can write and express your opinion on different issues related to constitutional law fearlessly. We have an ongoing article writing competition, the details of which you can access on our website, and currently we are also accepting blogs. We have published 80 plus well-researched articles and blogs which you can access on our website, the link to which is provided on the chat box. Today, as we commemorate Constitution Day, we reflect on the adoption of the Constitution, a cornerstone in the history of India. Our esteemed speakers will navigate the uncharted waters of technological progress and its impact on constitutional law. The rapid advancements in technology have ushered in a new era, bringing with it diverse legal and constitutional implications. This webinar promises a rich tapestry of discussions, keynote addresses, and interactive Q&A sessions. Our speakers will share their profound perspectives, providing participants with a comprehensive understanding of the challenges and opportunities presented by the digital age. Our objectives today are threefold. Firstly, to analyze the profound impact of digital technologies on constitutional principles. Secondly, to foster a dialogue on the evolving nature of constitutional rights in the digital age. And lastly, to provide a dynamic platform for legal scholars, practitioners, and students to engage insight and experiences. In the spirit of constitutional curiosity, let's embark on this journey of exploration together. We invite your questions, insights, and collaborative examination of constitutional law in the digital age. Before we dive into the enriching discussions on constitutional law in the digital age, let us take a moment to reflect on the essence of a guiding document by reading the preamble in English. In a constitution, the preamble presents the intention of its framers, the history behind its creation, and the core values and principles of the nation. So join me in reciting the preamble visible on your screens now. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. I now invite Ayush Kumar, who will recite the preamble of the Constitution of India in Hindi.
Hi, Sita. Am I audible?
Yes, you're audible.
Okay, thank you. Hello, everyone. Very good afternoon. Happy Constitution Day to all the participants. Now, let us start. हम भारत के लोग भारत को एक संपन्न प्रभुत्व संपन्न समाजवादी पंथ निरपेक्ष लोकतंत्रात्मक गणराज्य बनाने के लिए तथा उसके समस्त नागरिकों को सामाजिक आर्थिक और राजनीतिक न्याय विचार अभिव्यक्ति विश्वास धर्म और उपासना की स्वतंत्रता प्रतिष्ठा और अवसर की समता प्राप्त कराने के लिए तथा उन सब में व्यक्ति की गरिमा और राष्ट्र की एकता और अखंडता सुनिश्चित करने वाली बंधुता बढ़ाने के लिए दृढ़ संकल्प होकर अपनी संविधान सभा में आज तारीख 26 नवंबर 1949 ईस्वी को एतद द्वारा इस संविधान को अंगीकृत अधिनियमित और आत्मार्पित करते हैं। थैंक यू सीता। ओवर टू यू।
Thank you for joining us in this acknowledgement of our constitutional values. Without further delay, let's commence this webinar on constitutional law in the digital age. I now invite our first speaker, Advocate Nishant Verma sir, to share his profound insights on judicial perspective on digital constitutionalism. Mr. Verma is a seasoned advocate on record at the Supreme Court of India, having achieved this qualification in July 2022 on his first attempt. Mr. Verma brings forth a wealth of expertise in the dynamic field of law practice. A strong legal luminary, Mr. Verma holds a Bachelor of Law with a specialized focus on civil, criminal, constitutional, and commercial matters, among other vital subjects. With the demonstrated history of success, Mr. Verma stands as a stalwart legal professional dedicated to navigating the complexities of the legal landscape. Today, we have the privilege of delving into his insights and experiences, gaining valuable perspectives from a true legal virtuoso. Please join me in extending a welcome to Mr. Verma. Over to you, sir.
Thank you, Ishita. Happy Constitutional Day to everyone. Today, our Constitution Assembly have adopted the Constitution on this day. That's why we are celebrating Constitutional Day. Modi government in 2015 decided to celebrate Constitution Day. Before 2015, it was not celebrated. In year 2015, Constitutional Day started being celebrated by government. My topic is judicial perspective in digital constitutionalism. I shall confine my speech on this topic. So, uh, digital constitutionalism, according to me, is integration of technology with the sacrosanct provisions of constitution. Mainly, Article 14, 19, and 21 are three golden triangle of constitution, which is being recognizing Menka Gandhi versus Union of India 1978 judgment. It's a very landmark judgment. My favorite judgment is Menka Gandhi versus Union of India. After Keshwananda Bharati, I have tried to understand this judgment more than 3-4 times. So it's a very long judgment because in this judgment, due process of law has been elaborated, discussed very in a very wide terms. Article 21 speaks about right to life and liberty. You may have read Article 21. There is a word used in procedure established by law. Procedure established by law discussed in this judgment. Menka Gandhi versus Union of India. So Article 14 has a very long impact on all constitutional in every domain of subject. Let me let me off my camera, then I will better speak. So Article 14 is a very important fundamental right. which has you all can we, Article 14 discussed mainly in equality, speaks about equality of law and equal protection of law. I will I will deal with some judgments in which Article 14 discussed. मतलब judice. I'm little bit trembling. Sorry for disturbance. Let me start my discussion from Justice K.S. Puttaswamy versus Union of India. It's speak about privacy, right to privacy. Right to privacy is mainly recognized in K.S. Puttaswamy. It's embodied in Article 21 of Constitution of India, recognized in Article 21 of Constitution of India. Aadhaar judgment is also titled as Justice K.S. Puttaswamy versus Union of India. It came in 2019 and its citation is 2019 1 SEC 1. K.S. Puttaswamy's 9-judge bench judgment 2017 citation is 2017 10 SEC 1. So there are 9 types of privacy discussed in Justice K.S. Puttaswamy versus Union of India. Bodily privacy, spatial privacy, communication privacy, propriety privacy, intellectual privacy, decisional privacy, associational privacy, behavioral privacy, and informational privacy. In Secretary, Ministry of Information and Broadcasting, Government of India versus Cricket Association, Supreme Court recognized the freedom of speech and expression over different medium of expression. Supreme Court held that Internet has gained contemporary relevance and is one of the major means of information diffusion. Therefore, freedom of speech and expression through medium of Internet is an integral part of 19(1)(a), and accordingly, any restrictions on the same must be in accordance with Article 19(2) of Constitution. Article 19 speaks about freedom of speech and expression. Article 19(1)(a), mainly Article 19(1)(a) speaks about freedom of speech and expression, and 19(2) speaks about reasonable restrictions. This right provide the ingredients of Article 19(2) of Constitution are that the action must be sanctioned by law. Any reasonable restriction imposed by state means within the meaning of Article 12 of Constitution. The action, if you speak on any digital platform like YouTube, Instagram, Facebook, any audio, video you share on social media, that is subject to reasonable restrictions. You cannot speak anything that is prohibitory under Article 19(2) of Constitution. There are 8 ingredients of Article 19(2), which are very much important. Any public authority like district magistrate or any state government impose restrictions under Article 19(2) when there is threat or any apprehend of any communal insight, or there is any kind of hatred among community, then government uses Article 19 to impose reasonable restrictions. But these restrictions must be sanctioned by law. There must be some kind of rule before imposing restrictions. The imposed restrictions must be in furtherance of interest of the sovereignty and integrity of India, the security of a state, friendly relation with foreign states, public order, decency, morality, contempt of court, and defamation or incitement to an offense. Freedom of trade and commerce through medium of Internet is also constitutionally protected under Article 19(1)(g) of Constitution, subject to reasonable restrictions provided under 19(6) of Constitution. Like someone trade on Amazon or any Myntra, that is protected under Article 19(1)(g) of Constitution, freedom of trade and profession. But That article is also subject to reasonable restrictions under Article 19(6) of Constitution. In June 2019, Indian government released new amendment to the Information Technology Act in accordance with Section 87 of IT Act. There was amendment in Information Technology Act year 2000 in Section 87 of IT Act. There was a rule made in Intermediary Guidelines and Digital Media Ethics Code, Rule 2021. It made rules. The rules was made by Ministry of Electronics and Information Technology. It granted unrestricted authority to establish a fact-check unit for regulating social media platforms like Facebook and Twitter. These rules would require social media companies to take down any unlawful content within 24 hours, among other things, and to identify false or misleading content online. Any social media platform can take down any unlawful content if it found within 24 hours when it was circulated on social media. In transfer petition Anita Kushwaha versus Pushap Sudan, TP Civil number 1343 of 2008, Constitution Bench of Supreme Court held access to justice is fundamental right under Article 14 and 21 of Constitution. It's digital constitutionalism is also about access to justice. If anyone is too poor that it cannot approach Supreme Court to appeal in Supreme Court, then Supreme Court in Anita Kushwaha versus Pushap Sudan, transfer petition civil 1343 of 2008, recognized that access to justice is fundamental right under Article 14 and 21 of Constitution. Supreme Court held, we have therefore no hesitation in holding that access to justice is indeed a facet of right to life guaranteed under Article 21 of Constitution. The citizen inability to access courts or any other adjudicatory mechanism provided for determination of right and obligation is bound to result in denial of the guarantee contained in Article 14, both in relation to equality before law as well as equal protection of law. Absence of any adjudicatory mechanism or inadequacy of such mechanism, needless to say, is bound to prevent those looking for enforcement of their right to equality before law and equal protection of the laws from seeking redress and thereby negate the guarantee of equality before law or equal protection of law and to reduce it a mere teasing illusion. Article 21 is of the Constitution. Apart access to justice can be said to be a part of guarantee contained in Article 14 as well. The bench held there are four main facets of that constitute the essence of access to justice. The need of adjudicatory mechanism. These are all facets of Supreme Court recognized four facets of access to justice. These four facets are the need of adjudicatory mechanism. The mechanism must be conveniently accessible in terms of distance. The process of adjudication must be speedy. The process of adjudication must be affordable to the disputants. In 2018, Supreme Court allowed the live streaming of cases of constitution and national importance on the basis of judgment in Swapnil Tripathi versus Supreme Court of India in 2018. Gujarat High Court in 2021 became the first court in the country to live stream its proceeding. It was emulated by High Court of Karnataka, Odisha, Madhya Pradesh and Patna. One more important judgment that I found, which are very much important, is Anuradha Bhasin versus Union of India. In this judgment, writ petition civil 1031 of 2019. It's a just 4 years back judgment, 4 years ago judgment, in which Supreme Court recognized it's a 5-judge bench, constitutional bench judgment. Right to free speech and freedom to carry out one's trade and profession via medium of internet is fundamental right as under Article 19(1)A and 19(1)G. It's a very important judgment that I found relevant for this topic, judicial perspective in digital constitutionalism. Data Protection Act 2023, published in Gazette of India on 11th August 2023. It's a recent act, just this year passed act by Government of India. The objective of act is to provide for the processing of digital personal data in a manner that recognizes both the right of individual to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental there. An illustration was given in this Digital Data Protection Act. I would like to share the illustration. An individual, while blogging her views, has publicly made available her personal data on social media. In such case, the provisions of Act shall not apply, meaning thereby the Digital Data Protection Act shall not be applicable to X, shall not prevent her when she voluntarily shares her personal data on social media. The digitalization of court procedures is one of the most significant advantages of modern technology. The use of electronic technology can aid in reduction of paperwork, the improvement of accessibility, and the effective handling of cases. Court records digitalization can aid in making them more accessible, increasing openness, and speeding up the legal processes. In many of the adjudicatory forums, inter alia Supreme Court also, e-filing of cases is being done either by advocate or through party in person also. In Supreme Court also, e-filing can be done of cases by party in person. One of my cases in which I am respondent counsel, a party in person has filed a case in Supreme Court. Using e-filing can make the process of submitting cases faster, more efficient, and less expensive. E-filing can reduce filing time, increasing data accuracy, and eliminate the requirement of personal attendance in court. For example, Supreme Court of India e-filing platform allows lawyer and litigant to file cases and access case record online. There are also artificial intelligence and machine learning that is being adopted by Supreme Court. Currently, the Supreme Court have two tools in place. Supreme Court Vidhik Anuvad software, SUVAS, AI-enabled translation tool for translating orders and judgment into vernacular languages. Supreme Court portal for assistance in court efficiency, SUPACE. It is developed to function as an AI-based research assistance tool. So these are all, I understand that these are all access to justice to all the citizens across India. Either they may be poor or any rich person who may be litigant in any of the court, district court, high court, Supreme Court. I don't think that all district courts provide access to court proceeding through internet, but in Supreme Court these are all accessible. Access to court proceeding is Supreme Court has also launched its YouTube channel. Anyone can watch court proceeding through Supreme Court proceeding through their YouTube channel. In Sarvesh Mathur, I think this judgment is very important. Supreme Court has recently passed order in this judgment, and in this case, so Sarvesh Mathur versus Registrar General of Punjab and Haryana High Court, writ petition criminal 351 of 2023. Supreme Court directed all high courts to ensure that no member of the bar is denied access to video conferencing facilities or hearing through hybrid facility. The court directed the high courts to ensure that adequate internet facilities, including Wi-Fi, are made available free of charge to all advocates and litigants appearing before the high courts. The apex court also said that links available through video conferencing must be made available in the cause list of concerned court, and that there should be no requirement to make a separate application to appear through virtual mode. The court also directed that all high courts to put in place a standard operating procedure for litigant to avail access to hybrid/video conferencing hearings within 4 weeks. This order was passed on 6th of October 2023 in Sarvesh Mathur versus Registrar General of Punjab and Haryana High Court, writ petition criminal 351 of 2020. In Om Kumar versus Union of India, this judgment was mainly on doctrine of proportionality. I think it is an important judgment, because in this judgment Supreme Court held that any in this judgment Supreme Court propounded that judicial review of administrative actions that violates Article 9, that it recognized judicial review of administrative actions. Judicial review can be made under Article 226 in High Court and Article 32 in Supreme Court. Supreme Court found that administrative measures affecting basic freedoms, Article 19 and 21 in India, have always been judged on the doctrine of proportionality criteria, even when the doctrine of proportionality is expressly not cleared. Justice Puttaswamy judgment, Justice Sanjay Kishan Kaul has propounded doctrine of proportionality. Mainly, he has laid down four criteria that must be checked, that whether any order passed by a state or any government order can be checked, that whether it violate Article 14, 19, 21 of Citizen of India. 14 is not only about equality, it also about due process of law and procedure establishment. That the due process of law was first recognized in USA. It has been adopted from US Constitution. In Menka Gandhi versus Union of India, due process of law gained momentum, and it was held that due process of law is equal to procedure established by law plus procedure must be just, fair, and reasonable. Any law which was passed by any government authority within meaning of Article 12 must be just, fair, and reasonable. Justice Sanjay Kishan Kaul in Justice K.S. Puttaswamy 9 judgment, right to privacy judgment, ascertain that the action must be sanctioned by law. These rules, like intermediary guidelines and digital media ethics code, under which social media can take down unlawful content. If these rules were not in action, then it would be violative of Article 14, 19, and 21 of Constitution of India. Any state authority cannot take arbitrary action in taking down online content of citizen which has been transmitted or espoused on internet. So Sanjay Kishan Kaul ascertained that the proportionality can be ascertained on the basis of following: the action must be sanctioned by law, the proposed action must be necessary in a democratic society for the legitimate aim, the extent of such interference must be proportionate to the need of such interference, and there must be procedural guarantee against abuse of such interference. One more important section in Information Technology Act. Before 2017, Section 144 CRPC was used to impose restrictions in any town when any communal violence is apprehended by local government. After 2017, Section 69A of Information Technology Act was being used by by the government authority. Section 69A of an IT Act speaks about power to issue directions for interception and monitoring or decryption of any information through any computer resources. I would like to read this Section 69 of Information Technology Act, where the central government or a state government or any of its officer, especially authorized by central government or the state government, as the case may be, in its in this behalf, may, if satisfied that it is necessary or expedient so to do, in the interest of sovereignty and or integrity of India, defense of India, security of the state, friendly relations with foreign state, or public order, or for preventing incitement to the commission of any cognizable offense relating to the above, or for investigation of any offense, it may be subject to provisions of subsection 2 for reasons to be recorded in writing by order, direct any agency or the agency of the appropriate government to intercept, monitor, or decrypt, or cause to be intercepted or monitored or decrypted any information generated, transmitted, received, or stored in any computer resources. The subsection 2 says the procedure and safeguards subject to which such interception or monitoring or decryption may be carried out shall be such as may be prescribed. The subscriber or intermediary or any person in charge of computer resources shall, when called upon by any agency referred to in subsection 1, extend to facilities and technical assistance to provide access to or secure access to computer resource generating, transmitting, receiving, or storing such information, intercept, monitor. This rule mainly speaks about when any online content is shared, and it is prohibited under Article 19(2) of Constitution. Then within this section, the appropriate government can take down or restrict such content to share through internet. I think I have given my speech on this topic. Now, over to you, Ishita. You may told to share.
Thank you, Nishant sir, for sharing your enlightening insights on judicial perspective on digital constitutionalism. Your session has provided us with a profound understanding of this complex and evolving intersection of law and technology, backed up by legal precedents and provisions.
Initially, I was little fumble. Sorry to all the audience. Please don't get bothered. I seek my apologies.
Ladies and gentlemen, it is our distinct honor to introduce our second speaker for the day, Mr. Kumar Gaurav, Assistant Professor of Law and Program Officer of NSS Cell at Chanakya National Law University. Mr. Gaurav will speak on the topic Privacy and Data Protection in the Digital Age. An expert in his field, Mr. Gaurav holds a comprehensive academic background, having completed his LLB and LLM from the prestigious law school Banaras Hindu University. Mr. Gaurav further augmented his expertise by earning a Master of Science in Cyber Law and Information Security from IIT Allahabad, showcasing his commitment to staying at the forefront of evolving legal landscapes. His academic prowess is underscored by his qualification for UGC NET in 2013. As an educator, Mr. Gaurav imparts his knowledge both at the undergraduate and postgraduate levels, specializing in areas such as cyber law, medical jurisprudence, and forensics, as well as criminology, penology, and victimology. His dedication to the dissemination of legal understanding extends beyond the classroom, as he has served as a resource person, delivering impactful lectures in various governmental and non-governmental forums on cyber law and cybersecurity. We are privileged to have you, Mr. Kumar Gaurav, sir, with us today. Please join me in extending a warm welcome to this distinguished speaker. Over to you, sir.
Thank you, Ishita. Am I audible to all?
Yes, sir, you're audible.
Okay. Thank you once again. Before I start, happy Constitution Day to one and all the participants, organizers, and all the distinguished guests. It is very lovely to be here and sharing my views on the privacy and data protection in digital era. In the whole discussion, I will discuss the concept in 3 parts. First, I talk about how the concept of privacy originated, starting from the hunting age to this digital age. What are those paradigm shifts we have witnessed? And then we talk about, particularly in the digital age, what are those notions, what are those concerns which raised new challenges in realizing this fundamental right, which we call right to privacy. And the last part of my discussion will be that when the government passed the digital data protection bill, digital personal data protection bill 2023, how the concern of privacy had been addressed in that. We will also see the interface between the privacy law and the recent data protection, how they are interrelated, and sometimes there are certain overlapping contexts are there. So we will discuss in that direction. So moving further, I thank Nishant ji that he very beautifully discussed the aspect of privacy, the constitutional aspects, how the judiciary developed this right, and what is the role of judiciary in strengthening this right to privacy as one of the fundamental rights of our Indian Constitution. Look, when we talk about the idea of privacy, it originated from a Latin term. It's a privitus, which means when we talk about the literal meaning of this term, privitus, from where the term privacy was originated, it means set apart from public or personal and belonging to oneself. So one thing is very much clear: whenever we are talking about the privacy, it is something personal, it is something oneself, it is something setting apart from the public. So we are talking about the exclusion, we are talking about the solitude. I was reading a book called Privacy 3.0, authored by Rahul Mathan. He said that the solitude is the luxury which is availed by the animal of the highest in the food chain. And he very beautifully explained that how privacy evolved. So let me begin with that how the concept is starting from this the term, how we travel. But before coming to this concept, the term, the privacy, the privitus, let me take you to the hunting age. When we are the hunters, we are living in the jungles, and what was the concept of privacy that time? All the anthropological studies shared their views that privacy, like a concept which we understood, which we understand in the today's scenario, which was not there. And why this is so? The people are living in caves, and that hardly they get any place for intimacy. There is a place called a privacy, or there is a place called exclusion. They live in a herd, and which we call it, they live in a jund, and the idea was there, so that if they will in a herd, and this is very helpful to protect from the wild animals, And there was no such concept of privacy living in exclusion. So this was the very early age when we are living in a hunting age. Later on, when we started move from this hunting age to the agriculture world, and initially we started developing the societies and the cities and the villages and cities were developed. Then we started talking about the concept of privacy. Then the journey of privacy started when we moved from the jungles to the land, and when we started cultivating, when we developed the concept like privity, this is mine and this is yours. From there, we started the concept of property, the concept of privacy. If you go through with the writings of Aristotle, he talked about the Greek philosopher. While explaining the idea of privacy, he said that while explaining the privacy, he said that it is a division between the public sphere and the political public sphere of the political affairs and the personal affairs. So he used the term polis and the okilos, polis for the political affairs, and when he was talking about the personal affairs, okios. So he divided that there is a concept we call the public sphere, there is a concept we call the personal sphere. Later on, if you go through with the concepts like the William Stone, William Blackstone, he while explaining the ideas of the privacy, he said that at a certain level of evolution, doctrine of privacy was followed the public-private distinction. Although the early writings is not specifically differentiated that what exactly is the privacy, the whole concept of privacy was very much there enshrined in the concept of public and private. John Stuart Mill, while explaining on liberty, he expressed that in his famous essay on liberty, he said that in 1859 that the need of preserve a zone within which the liberty of the citizens would be free from the authority of the state. According to Mill, I just quote within inverted comma, the only part of conduct of anyone for which he is amenable to society is that which concerns others. In the part which merely concerns himself, his independence is right absolute. Over himself, over his own body and mind, the individual is sovereign. So you see that how initially the various authors tried to explain the idea of privacy. The Austin, in his lectures of jurisprudence, he while explaining the idea of privacy, again he tried to explain it with the help of just publicium and just privatium. So while explaining these two context, he explained the idea of privacy. Even the medicine, like he concerned and he tried to explain the privacy, and he said that medicine traced that the recognition of inviolable zone to an inalienable right to property. Property is constituted in the broadest sense to include intangible and intangible, and ultimately to control over one's conscience itself. So the medicine tried to explain it in the context of property also. But the greatest change and the revolution, whenever we talk about the concept of privacy, whenever we have to discuss the idea of privacy, it is not complete without citing the writings of the Samuel D. Warren and Louis Brandeis in the 15 December 1890 in the Harvard Law Review. They talked about the author one very famous article, one of the celebrated article. Whenever one has to understand the very philosophy, the very idea of privacy, one must read that article. It's a old article, but it's still having the relevance whenever we have to understand the initial idea of privacy. And while explaining the idea of privacy, he alluded to the evolution to the law, incorporate within it the right to life as a recognition of man's spiritual nature of his feelings and intellect. So he come up with the idea as a legal right, where broaden the right to life, and had come to mean that the right to enjoy, the right to be let alone. While explaining the Judge Coley that the everyone's house is his own castle, Brandeis very emphatically explain that the concept of privacy and the right of privacy, that what exactly the privacy is there. So these were the very initial phases of privacy which we have discussed in a very brief. But when we move further means when I'm saying that we have moved further, like when we transform due to the transformation in the society, and particularly in this transformation, technology is one of the instrumental thing for this change and this transformation in the society. So with the inclusion of technology and the reliance of technology by the society, by the people, that how it transformed the concept of privacy and how it became the challenging. To make you understand that this challenge, I just talked about the three authors here that who talked about this challenge and this change. Those three authors are, one is a very famous author, Alvin Toffler. Another is Max Tegmark, and third is Klaus Schwab. Alvin Toffler, in his book Third Way, 1980, is a futurist and author, and he talked about the three revolutions. And in those three revolutions, he talked about the first revolution is the agriculture one, the second is the industrial, and the third he talked about this IT revolution, computer or digital technology generated revolution. And whole context of his idea of revolution is that although these three major revolutions transformed the human civilization, there is a great impact on the human civilization. But when we compare it, when we particularly compare the IT revolution in comparison to the rest of the two, the time span of IT revolution is the shorter in comparison to the rest of the two. But when when we talk about its impact is the huge in comparison to the agriculture and the industrial revolution. Likewise, Max Tegmark in his book Life 3.0, he talked about the three like the biological evolution, then the cultural evolution, then the last Life 3.0, he talked about the technological evolution. Like where the technology, when we started using the technology in our day-to-day life to a great extent, that how it transformed our life. And the third author was Klaus Schwab. He authored a book called Fourth Industrial Revolution, and he said that we are living in exciting times of human transformation, and this transformation is huge in terms of its size, scale, and scope. If you see that the way that IT, particularly this digital technology, having impact in our life, this is huge in terms of its size, the how much it is faster than the other technologies, and its scope. Hardly there is any area, hardly there is any field which is uh, which is we are which is left for the this IT. Now let me tell you, when we talk about these three authors, I purposely discussed these three authors. The idea was that they try to explain the significance of this IT revolution, and in all three, almost they are agreed on this point that this change is inevitable. We cannot stop this change. In fact, change is a huge, and this is a sea change, we can say that, and it transformed the way we are thinking, the way we are living. It transformed everything, and likewise, it also transformed the various legal concepts, with the concept of property, with the concept of various rights, and amongst that, here we are not concerned about the other aspects. We are concerned with the amongst those rights, particularly the right to privacy, that how privacy has been transferred due to this IT transformation. There was an author called Bruce Senior. Bruce Senior, in his book called Data and Knowledge, he said that your cell phone tracks where you live, where you are. Now you can see even a cell phone having such a great role to play, particularly when it comes to in our day-to-day life. But at the same time, it is one of the operators, one of the device which become the threat to our privacy. Let me tell you, when we talk about, it has been said that if you are in my friend list, like if you are through any social media, if you are in my friend list, that half of your privacy is in my pocket. Meaning the way we are sharing the content on these platforms, these social media platforms, which are interconnected to each other, we share there are numbers of those information which may threat to our privacy. And that's why it has been said that if you are in my friend list, that half of your privacy is in my pocket. So it challenged the very fundamental notion of the right to privacy. But let me explain you that how basically it is become evident, and how it became the reality, how challenging this fundamental notion, that the right to privacy, and how this technology is challenging. For that, we need to understand the very ecosystem, the ecosystem we call the IT ecosystem, the cyberspace ecosystem, or this digital ecosystem, that how it functions. When we talk about the internet, or when we talk about the cyberspace, although they're interchangeably, we are using the cyberspace and the internet, although there is in a strict parameter, there are certain differences are there. but we are let me go to the delve while talking about the characteristics of this cyberspace. There are four basic characteristics of that. It's a borderless phenomenon, it having the speed, it's an interconnectedness and anonymity. These the four basic features are there as for this cyberspace is concerned. Amongst all, particularly this interconnectedness means the computer. What is internet? Internet is the interconnected network of computer network which are globally distributed and globally connected to each other. So interconnection is one of the basic element which is very crucial to understand that how it is challenging our privacy. Let me explain you. It has been said that if you are accessing on internet, if you are accessing internet, internet is also accessing you. You might have witnessed while accessing YouTube or while purchasing anything on any of the web portals. What happens sometimes, like you are interested in purchasing books, when you're interested in purchasing books on the idea of particularly the cyberspace or the cyber security, and then you just log out, and again if you rejoin and you start the account and now you trying to order, then you will find the similar sorts of books are available in the list. It's so that whatever you have searched, on the basis of those search, I will take up the question at the end. Certainly, I will be happy to answer, but at the end, I will take up the questions. Okay, Gurdeep, I will take up the question at the end. Okay, so while I was talking about that these behavioral advertisements and become possible due to this interconnectivity, the very feature of internet. And this is the concept which also provided the idea of the digital surveillance. And it has been said that we always say that we are living in a surveillance world and everything is connected, and every minute feature can be this, and the privacy is myth in the digital era. This is the reason that this interconnectivity. But the thing is whether it can be protected, this surveillance can be controlled, can be regulated, this behavioral advertisement can be regulated. If yes, that what are the ways out we have? Look, when it comes to the regulation, we talked about the regulation. When it comes to the regulation of cyberspace, when we talk about regulation of cyberspace, then it is different from the regulation of physical space, and because of its very infrastructure which we have just discussed. When it comes to the regulation, we have the, like in India, that how we are regulating this cyberspace. We have the IT Act. Recently, we framed the Digital Personal Data Protection Act. Two prominent provisions. Apart from that, the government is also going to bring certain amendments, particularly in the Broadcasting Ministry, and the DOIT, Department of Telecommunication, is going to bring certain mechanism to regulating the OTT and all that. A few years back in 2021, we had the Intermediaries Guideline, Digital Media Code Ethics 2021. So these are the existing mechanisms we have by which we are protecting our right. Although initially we have the other legislation by which we are trying to regulate particularly the concern of privacy, like through the constitutional framework through the other legislation, through the IPC, through the contractual obligation, through the contract, we are trying to protect it, the right to privacy. But when it comes to the digital world, it becomes the very challenging, and that's why we need to go for the framing of the new legislation, which may able to regulate this privacy in the realm of digital era. Let me give you the insight that what exactly the provision we have in the IT Act. When we talk about the IT Act and the provisions related to that, what we very few provisions which are directly concerned with the privacy. There is one provision called 66E, which talks about the violation of privacy. This whole provision is very much concerned with the bodily privacy. If you install any camera, spy cam in the changing room, then this provision will be applicable. So this provision is concerned with the bodily privacy. Like BJ Coops, while talking about the topology of privacy, and Nisanji also in his address, he talked about the various layers of privacy. He was talking about the various layers, which had been BJ Coops, that topology of privacy were well quoted, also quoted in the privacy judgment, the Justice Case Putta Swami judgment, that the various layers, one must read to understand the various notions of privacy, the various types of privacy. While he explained that the various types of privacy, there is another provision is also there, that in which the concern of confidentiality and privacy has been addressed. In that context, the idea was it's a context of informational privacy. So there are two specific provisions we have in the IT Act, where we talked about the protection of privacy, and the rest of the and apart from that, the provisions which we have, that are indirectly talking about the protection of privacy. So here we see that is 66E, then there are 72, and particularly the 72A. There are three provisions in the IT Act which we directly or indirectly talking about the concerns of privacy. Now, recently in the year after the struggle of a decade-long struggle, we have the Digital Personal Data Protection Act, where the concern of privacy has been duly addressed. But before that, we need to understand that, like my second part of the last part of the discussion will be what exactly is the concern of data protection, and that how privacy has been addressed in that context. If you talk about the data and the concern of privacy, and how this law is addressing the concern of privacy, for that you need to be clear about the this legislation which we call the Digital Data Protection Bill, and what is the strength, and what are the concerns of privacy there in that bill, and what are how effectively it addresses the concern of privacy. You know that this Digital Data Protection Bill, when we talk about, this is all about all the personal data which is a digitized form. It talks about the personal data, sensitive data, that it protects both. Although it's not specifically mentioned the non-personal data, the earlier the Personal Data Protection Bill, before this enactment, the old versions of the data protection regime in India, in the earlier bills, the non-personal data was also there. The recent bill, the non-personal data, in recent act, the non-personal data was not effectively addressed. Now, there are two concerns there: the personal data and sensitive data. And we see that the whole IT ecosystem is based on the data, and it has been said that we are living in a data-driven world. And this data-driven world, there are numbers of complications arises, and I will let you know the some of the concerns of this privacy concern, particularly in the data protection regime, and that with this new legislation, although try to explain and try to uh, regulate the concerns of data and the data principles and the users, the protection of the users' data. But apart from that, there are certain concerns which we needed to be addressed, like the concern of notice, consent, and how data is processed. That the issue of notices, the issue of consent, who is allowed to give consent and who is capable of giving consent, the how the consent has been processed, what is the processing of consent, particularly in the while we talking about the consent, the children's privacy is one of the greatest concern in the recent enactment. And the children and privacy, when we talk about, then there is a consent that what will be the who, when, how it can be regulated. Although it say that on behalf of the children, their parent can go for the giving the consent, but how it will be formalized and how it can be keep checked on that, what is the mechanism we have. So the children's privacy, although we have the provisions for that, but still how much time I have, because Isita, how much time I have to complete it?
Sir, the stipulated time is about to end, so you may start summing up.
Okay, just 2 to 3 minutes to sum up. Then I will take at the end the questions and the question
Sure, sir.
answer. Okay. Now, I was talking about the context of consent is one of the crucial issues there. I'm giving you one practical insight that how sometimes the privacy concern is one of the aspect is that how time, and the data retention is one of the concerns. When how a person is how any entity is retaining the data, how much time they can retain your data, what exactly is the timeline, and whether they are removing those data after once. Although the data protection bill is talking about that the way out of the retention policies is talking about, but maybe in a practical scenario, I'm telling you that there is so much variation as for the data retention policies followed by the most of the organizations and the institutions. So there need to be the data retention policies, one of the concern. I was talking about one of the practical problem, like if someone is ordered uh, uh, through the Flipkart or through the Amazon, anyone ordered that any of the goods for you on your name, you haven't ordered. He shared all your personal details to that entity. In that scenario, so you have not consented for that, but someone ordered on behalf of you. So your personal data has been shared by someone. In that scenario, whether this recent enactment is able to regulate those concerns also, where someone is sharing your data and someone is giving consent on your behalf. So up to what extent that data can be retained by that entity, and whether how the consent is regulated in that context. So these are certain gray concerns are there. The bill, the enactment is the newborn baby, and we have to see that how it how effectively it address the concern of privacy and the rights of user in coming days. Although there is a time constraint is there, but I must say that there is one concept is left for the discussion, which I thought that it will be great if we will include that aspect, the aspect of the surveillance. There is two things are there, three things are there: the surveillance, security, and privacy. Like, to increase the level of surveillance, to increase the level of security, you increase the level of surveillance. Like, you started installing the CCTV cameras everywhere. Once you raise the level of surveillance, you started invading the privacy. So there is a need to be set a harmonious construction among the security, privacy, and surveillance. And this is one of the daunting tasks before the legislature, that how to settle this sort of issues, contentious issues, where that all three are interrelated and particularly become a problematic thing to answer, that how to settle a harmonious constructions among that. So coming to the end, I must say that we are living in a digital world, and there are so much transformation is there. Recently, the AI, the generative AI, the chat GPT we have, and it has been once said regarding the AI that we are summoning the devil. The Elon Musk once said that we are summoning the devil, and the devil is here. And it is the irony that most of his project of Elon Musk is based on the AI only. So that how AI is the threat to privacy, we have to see that how through the AI we can protect our privacy, whether it can be a safeguard or whether it is a threat to the privacy. So the coming future, the coming days we will able to assess that how this technology, whether it is boon or bane as for the privacy right is concerned. Thank you. Over to you, Isita.
Thank you, Mr. Gaurav, for delivering an insightful session on privacy and data protection in the digital age. Your articulate presentation was not only engaging, but also demonstrated a depth of understanding in the technical aspects. The use of legal maximums added a commendable layer of precision to your discourse. Your creativity in bridging the old legal thesis and classic literature with the present digital era not only showcased your wide understanding, but also prompted the audience to think outside the box. We will be mindful as to who is in our friend list, as to not give away half of our privacy to them, and always remember that when we are accessing internet, the internet is also accessing us. Thank you, sir. It is a great honor to present you our third keynote speaker of the day, Honorable Vice Chancellor of the National Law University, Tripura, Professor Yogesh Pratap Singh, a distinguished legal scholar. In spite of his busy schedule, as the NLU Tripura is also celebrating Constitution Day, Sir has been kind enough to grace us with his presence today. He will be covering the topic of free speech and expression online. Professor Singh's academic journey is marked by excellence and a deep commitment to the field of law. Having earned his LLM from the esteemed NLS-IU Bangalore and LLB from the University of Allahabad, Professor Singh's academic foundation is robust and diverse. His doctoral thesis, titled Contribution of Dissenting Opinions of Indian Supreme Court Judges to the Indian Legal System, a Critical Evaluation, is recognized as a significant contribution to understanding the intricate voting patterns within the Supreme Court of India. Professor Singh brings a wealth of experience, having served as Deputy Registrar of Research in the Supreme Court of India from May 2016 to October 2018. His international exposure includes participation in the 39th Annual Session on International Human Rights Law, organized by the International Institute of Human Rights in Strasbourg, France. Prior to assuming the role of Honorable Vice Chancellor at the National Law University, Tripura, Professor Singh held the positions of Professor of Law and Registrar at NLU Odisha. He played a crucial role in the founding team of KIT Law School, KIT University, Bhubaneswar. A prolific writer, Professor Singh consistently contributes to the field of law, sharing his insights in reputable law chronicles and national and international law journals. Today, we are privileged to have Professor Singh with us, ready to impart his vast knowledge and experience. Please join me in extending a warm welcome to Professor Yogesh Pratap Singh. Over to you, Honorable Vice Chancellor, sir.
Thank you, Ishita. Am I audible?
Yes, sir, you're audible.
Okay, good. So thank you so much for inviting me and giving me this opportunity. I'm truly honored, humbled. We are today celebrating 74th Constitution Day, and I wish everyone a very happy Constitution Day. I wish and pray that principles of justice, equality, affinity, common brotherhood, all will guide all of us. Uh, Thank you so much for giving me this opportunity and ask me to speak on freedom of speech and expression in the age of internet. Hmm. We got freedom in 1947, and upon realizing this freedom, the dream of independence in 1947, we prepared and adopted a constitution which became effective from January 26, 1950. And it's one of the cherished objectives that every individual in this country, every citizen of this country will have liberty of thought and expression. So this is mentioned in the preamble. And then we have Article 19(1)(a) of the Constitution. This provision 19(1)(a) was designed to afford the people of India the kind of measure of liberty available to the individuals in United Kingdom, United States. The Constitution indeed departs from American and British system in major points of form, technique, and method also. But the deviation from British and American Constitution does not or do not derogate from underlying principle of individual liberty, especially in case of freedom of speech and expression. So, as already we know as a student of law that no freedom, no right is absolute. And that is why Article 19(1)(a) also provides certain restrictions, which we can see in Article 19, Clause 2. So apart from specific and more or less well-defined categories of legal restrictions covered by libel, slander, defamation, contempt of court, decency, or morality, the general test to be applied in case of freedom of speech was whether the matter sought to be inhibited, undermines the security of the state, or tends to overthrow the state. So the impugned law will sustain if it related to matter undermining the security of a state or tending to overthrow the state, notwithstanding the fact that it is in restraint of freedom of speech and expression. But if you see the interpretation of Article 19(1)(a), and if we compare this interpretation with the interpretation given by the Supreme Court to other provisions of Part 3 of the Constitution, means other fundamental rights. It may be equality, it may be freedom of religion, it may be the most sacrosanct freedom given under Article 21, the right to life. And if we compare this with Article 19(1)(a), we find that freedom of speech was put on a more unaccessible foothold than other freedoms guaranteed under Part 3 of the Constitution and under Article 19, because 19 has so many other freedoms. So right from the beginning, Article 19(1)(a) received a kind of very progressive interpretation from the apex court, from the Supreme Court, which even Article 21 could not receive. If you see Article 21 cases, you will find a restrictive interpretation given by the Supreme Court. Similarly, Article 14, you will find a restrictive interpretation given by the Supreme Court in the initial phases. The liberal and creative and progressive interpretation started later, when we say judicial activism and all these phrases. So 19(1)(a) was very, very fortunate that we received a progressive interpretation starting from Ramesh Thapar versus State of Madras, Brij Bhushan versus State of Delhi. Article 19 did not expressly provide for freedom of press, but if you see the series of judgments, whether it is Sakal Papers Limited versus Union of India, Bennett Coleman versus Union of India, Indian Express Newspapers Limited versus Union of India, the Supreme Court was very categorical and very clear right from the inception that freedom of press, though it is not expressly mentioned in 19(1)(a), unlike American Constitution, but it is the integral part of freedom of speech and expression. So freedom of press is also part and parcel of Article 19(1)(a). There are other notable judgments like R. Rajgopal versus State of Tamil Nadu, where Justice P.G.1 Reddy reiterated the importance of freedom of press. New dimensions were added in number of other cases like Secretary Ministry of Information and Broadcasting versus Cricket Association of Bengal, where the court held that government has no monopoly on the electronic media and a citizen has right under Article 19(1)(a), a right to telecast and broadcast to the viewers and listeners through electronic media. Tata Press Limited versus Mahanagar Telephone Nigam Limited, another 3-judge bench of the Supreme Court, held that commercial advertisement is also part of the freedom of speech and expression. The latest in this line was the recent landmark judgment of Shreya Singhal versus Union of India, which once again is a delightful affirmation of the value of free speech and expression, quashing 66A of the Information Technology Act 2000 as unconstitutional and arbitrary. The Singhal case is important for various reasons. It not only represents the courts taking an extreme step by declaring a censorship law as illegitimate, but it illuminated with remarkable felicity the scope of freedom of speech and expression available to a citizen and the limited role for the state to put restrictions on this freedom. The Supreme Court also clearly stated that freedom of speech offline is equal to freedom of speech online, a principle that has already been recognized very clearly by the United Nations. So Shreya Singhal was a very critical step for free speech jurisprudence, with the courts taking a firm stand in favor of the right to free speech on internet. So freedom of speech and expression is one of the essential, one of the most cherished freedom which is guaranteed under the Constitution. And we discuss in the class when we teach Article 19(1)(a) that what is the purpose of freedom of speech and expression? Why freedom of speech and expression is required? And then I find three distinct justifications in the realm of philosophy which rationalizes the importance of free speech. The first justification, the first typology, it is stemmed from a pledge to holding those in power accountable to the people, to hold power holders accountable to the people. And we call it accountability justification. Accountability justification of freedom of speech and expression. The second typology is stemmed from the idea of individualism. And we call it liberty justification. And the third comes from a pledge again to discover truth. And that is truth justification. So there are three distinct justifications in the realm of philosophy for freedom of speech and expression: accountability justification, liberty justification, and truth justification. Accountability justification are used at power holders in the society, the state, various organs of the state. Three principal organs of the state are essentially self-interested, and they should be accountable. They have been given power by the Constitution, by the people, and they are accountable to the people. And freedom of speech is deployed as one of the most effective means. So the accountability argument challenges the authority of the power holders and attempts to public scrutiny of the governmental action, and also point out the faults in governance with its political, epistemological, and moral dimensions. The liberty justification upholds freedom of speech as an indispensable manifestation of the natural rights of free man. People will not be able to develop intellectually and spiritually unless they are free to formulate their own beliefs and political attitudes through public discussion and in response to the criticisms of others. This was also categorized as positive and negative liberty. Positive liberty is freedom to, and negative liberty is freedom from. Freedom to means freedom to express oneself as directed by one's own rational energies, like freedom to speak, freedom to communicate, freedom to convey, freedom to express, freedom to dissent. The negative liberty is freedom from, Freedom from comes from the notation of individuality and its protection from external forces, including freedom from censorship. The famous political scientist, philosopher John Stuart Mill, and his writing famous essay on liberty underlines this concept of negative liberty. Mill, if I request all the students, all the participants to read on liberty, this essay of John Stuart Mill, if you get time, because in his essay, he attempts to justify freedom of speech from various perspectives. And he also asserts this perspective, which asserts the search for truth as a key manifestation of expression of individuality. The third, truth argument, truth justification of freedom of speech and expression. If you remember the beautiful lines of J.S. Mill, where he writes that if all mankind minus one were of one opinion and only one person was of the contrary opinion, mankind would no more be justified in silencing that one person than he, if he had the power, would be justified in silencing the mankind. By this statement, he highlights the phenomenon called dissent. Dissenting opinions, right to disagree, right to have a different opinion is the hallmark of the inquisitive spirit of the mankind. He also gives justification in his essay. If the opinion is, suppose the opinion is true, the opinion of that one individual, if it is true, then by suppressing that opinion, humanity may be deprived of truth. Maybe that one individual is going to speak truth. And if humanity is deprived of truth, humanity will not progress. Now, there is an equal chance that opinion is false. Opinion may not be true. He again writes that even if it is false, humanity again loses. Because if the opinion is false, it will be shown to be so. And people will know at least that this opinion is false, this is not true, which is equally important. Friends, truth is very dialectic. You can't define truth in one line, in one passage, in one paper, like justice. Truth is very complex. That is why we study theories of truth, like theories of justice. So unless you allow discourse, debate, dissent, you will not reach to the truth. And therefore, humankind benefits when a person is permitted to express his views freely. When a person is allowed to express himself or herself, if you see the history of science, when Einstein gave his principle of relativity, the people were not ready to accept. They said, oh, this is bogus. What nonsense he is talking about. If you would have stopped Einstein, the mankind would not have progressed. If you have stopped Galileo, mankind would not have progressed, because Galileo, Copernicus also challenged the long-held notion that Earth was the center of the solar system, and the society was after them, that they are talking nonsense. But these dissents later became truth, later became the consent of the day. And similarly, if you see the spiritual dissents, religious dissents, the history of spirituality also shows that the dissent and freedom of speech has developed the evolution of religions. Buddhism developed as a dissent against several vices existing in the Hinduism, like caste system, like rituals, like spirits or the devils. Jainism also grew as a dissent that emphasized on non-violence and the respect for all living beings. Christianity emerged in the Roman Empire as a religion of dissent, and eventually becoming the dominant religion of the empire. Islam emerged in 7th century in the Arabian Peninsula as a dissenting religion. So history of science, history of religion is also a series of ruptures and dissents. And if you don't give people to express, you will not evolve, you will not develop, you will not progress. And that is why probably one of the reasons that why Supreme Court was very kind to freedom of speech and expression right from the beginning, from 1950, when other fundamental rights were given restrictive interpretation, right under 19(1)(a) was given a very liberal and progressive interpretation. Till Shreya Singhal versus Union of India 2015 judgment. But Section 66, capital A, was struck down by the Supreme Court in Shreya Singhal. But you will be surprised that there is a growing tendency of over criminalization of free speech in recent time. There is a research conducted by this Internet Freedom Foundation, IFF. And in 2018, this group, IFF, Internet Freedom Foundation, they found that Section 66A is still being utilized to prosecute individuals all around the nation. And based on this information, given this report given by Internet Freedom foundation, PUCL, People's Union of Civil Liberty, they approached Supreme Court. They filed a petition in the Supreme Court. And it was found that around 200 cases were pending before the court when this provision 66 capital A was struck down. 200 cases were pending in 2015. And the new report, 2018 reports, it demonstrate that even after March 2015, 1,300 cases were registered under the law. 1,300 cases across the country were registered under Section 66A of the Information Technology Act. It's very surprising that cases are being registered under a law which has been declared unconstitutional, which is being declared arbitrary by the apex court of the country. Because nobody reads footnote. In the Bare Act, if you, as a student of law, you must have seen, so when a law is declared unconstitutional by the court, it will not remove, it will not go from the statute book. It will remain in the statute book. Only a footnote will come that this law has been declared unconstitutional and arbitrary by the Supreme Court of India in this case. Because repealing is not the judicial function. Repealing involves a legislative act, legislative function. And legislature will not get time to repeal these kinds of provision. I remember Section 303 of IPC was declared unconstitutional in 1984. People who have done IPC, they would have recalled that case, Mithu Singh versus State of Punjab. Section 303 of Indian Penal Code was struck down, which provided capital punishment to a person who commits murder. Capital punishment to person who is serving a life imprisonment, who is a life convict, and he commits murder, he will be given capital punishment. This provision was struck down. That this is not required. This is not a reasonable classification. This is against Article 14 and 21. But even today, you will find in the IPC that provision, only with a footnote that this provision has been struck down by the Supreme Court in Mithu Singh versus State of Punjab. So same thing applies to Shreya Singhal versus Union of India. 2015, the provision was struck down, but in spite of that, cases were being registered under Section 66A. And not 1, 2, 3 cases, 1,300 cases. 1,300 cases. So the 3-judge bench headed by the then Chief Justice of India, Justice U.U. Lalit, he issued an order on October 12, 2022 in the petition filed by the PUCL. And the direction was issued by the court to the central government and the courts across the country to ensure that cases are not registered under the outlawed provision 66A. And the Supreme Court also declared that such criminal proceedings, in our opinion, are directly in the teeth of the directions issued by this court in Shreya Singhal versus Union of India. Bench further directed that those cases where the alleged violation has been projected and the citizens were facing prosecution for the alleged violation of the law, the difference and reliance upon the said section from all these crimes or criminal proceedings shall stand deleted. The Apex Court directed state police chiefs as well as the home secretaries and competent officers in the union territories to instruct the entire police force not to register any complaint or crime with reference to any violation under Section 66A of the IT Act. So, and that is why I said that there is a growing tendency of over criminalization of free speech in recent times. I gave you one example because our discussion was based on freedom of speech and expression online, but there are other examples. Misuse of sedition law, which finally Supreme Court forced to stop registering cases under Section 124 capital A of the IPC. There is a growing excessive use of Unlawful Prevention Activities Act. Number of cases are rising. The number of, if you see the conviction rate also, it's a very, very negligible. So you register cases, conviction is very, very low. And after so many years of violation of your liberty and right, you will be declared that no, there is no case against this person. But who will pay? Who will return the violation which has already taken place? There is a violation of National Security Act. There is a criminal law on defamation has also been misused. This is also colonial law. It was challenged in the Supreme Court, and Supreme Court had the opportunity to declare it unconstitutional. But sometimes Supreme Court also fails us. In spite of this fact that I mentioned right from the beginning, Supreme Court was very generous and Supreme Court was very kind enough with respect to freedom of speech and expression. So freedom of speech is very, very crucial fundamental right. But the general trend is not very progressive. I was looking at the World Press Freedom Index 2021, which ranked India at 142 out of 180 countries, which means, and this is as per the report, that India is one of the most dangerous countries for journalists trying to do their job properly and honestly. And one of the primary reasons cited for this, that in addition to continuing factors, was the rise of nationalism, religious right-wing sentiments, which is trying to tightening the noose around media. So you will find gag orders, you will invoking sedition charges, hate campaigns, threats, violence. So, and the courts have also been suspicious of declaring detention order invalid on account of vagueness of grounds communicated to the detainee. So, due to this inconsistent jurisprudence, the courts have accepted a very broad interpretation of activities which are prejudicial to the public order. So, freedom of speech is probably, in my opinion, one of the most sacrosanct fundamental right after right to life, because right to life is the condition precedent. Freedom of speech and expression and freedom of dissent is the most important fundamental right in a democratic setup. Supreme Court has been very generous, very progressive, barring few exceptional provision. But the current trend is not very progressive. So I will stop here. Thank you very much for giving me this opportunity.
Thank you, Professor Singh, for delivering an engaging session on free speech and expression online. Your exploration of this fundamental right, emphasizing its role in holding those in power accountable, granting liberty to individuals, and facilitating the pursuit of truth, was enlightening. The inclusion of pertinent case laws such as Shreya Singhal and People's Union for Civil Liberties judgment provided a comprehensive legal perspective. Your discussion on the equivalence of freedom of speech offline and online, as well as exploration of negative and positive freedom, added depth to our understanding. We all will surely read John Mill's essay on liberty. We appreciate your insightful contribution to today's webinar. Now, I would like to hand over the reins to Ayush, who will be moderating the question and answer session. Ayush, over to you.
Thank you, Ishita. Thank you so much, sir, for your insightful talk on the sub-theme. Now we transition towards the question and answer session. I encourage all participants to take the opportunity to seek clarity and share their perspectives. Since Gaurav sir has to leave early and see he has other commitments, he'll be answering the questions posed to him in the chat box. You may address your question in the chat box to the specific speaker, ensuring a constructive and fruitful exchange of ideas. Kindly be respectful while asking a question, following basic human etiquettes. Your active participation is pivotal in making this dialogue truly enriching. Over to you, Gaurav sir.
Okay. Thank you, Ayush. Before I go for answering some of the queries, first of all, I thank Professor Vice Chancellor sir for delivering a wonderful speech. It's really nice to listen you, sir. Thank you, sir. So now coming to the two set of questions, as I said that I have to attend one event. So coming to the question related to the child protection and the privacy concern, that how privacy is to be protected in the context of child, and who will be the person who is giving, who is the person authorized for dealing with the consent related aspects. One thing is very much clear: if the idea is great, if the issue is great, that the answer cannot be in the black and white. If you say that how it can be materialized as for the consent is materialized, I'm telling you, first I will let you know the provision, then I will let you know the problem and the practical problem, and why I'm saying that the answer can't be in the black and white. Let me talk about the provision. As for the Digital Personal Data Protection Act 2023 is concerned, Section 9, if you read Section 9, I just read for you. The data fiduciary shall, before processing any personal data for a child or a person with disability who is a lawful guardian, obtain verifiable consent of the parent of such child or the lawful guardian, as the case may be, in such manner as may be prescribed. There are two major concerns are here. Although the data fiduciary has to take care of that before the processing any of the data related to the child. Although the child, as per this digital data protection bill is concerned, if you go through the definition clause in the 2(1)(f), it's explained the child means an individual who is not completed the age of 18 years. Why purposely I read the definition of child, the age concern? There are three major concerns have been raised by the industry related to this aspect. First, that is what should be the age. Like, take the practical aspect. If you are going for any research and you have to access live law, if you have to access the Rambursa portal, for each and every time any intermediary is processing your data, any service provider is processing your data, they need to have a consent if you are below the 18 years of age. The second thing, that what should be the age? Do you think that 18 years of age in the current context is the right, or whether we need to lower down? And what is the international scenario? What are the other parts of the world? What is the age of consent? This is the first area which is still the debates are going on, the discussions are going on. What should be the age of consent? Second, how it will be materialized, like data fiduciary, before processing it, they have to take the consent from the parent. In the case of children, and in the case of disability, particularly the guardian, local legal guardian. Now the parents, how they will give the consent. There are three basic way by which we can say that the consent can be materialized. Generally, what method which can be applied? First method, which is the most prominent method we can go for, although the method has not been specifically mentioned that which is the method, because we are still waiting for the rules. And the most probably in the month of by the end of this year, we have the rule for the comments on the data protection bill, the data protection act. Then we have the specific guideline that how the consent will be obtained. Let me tell you that the concern, what the way out we have. First, we go through the ID verification. This is one method, but again, there is a problem is there, the ID verification, which ID and what sort of ID which can be taken into consideration, what is the veracity, the genuineness, the authenticity of that ID. The second is that we can use in the context of the self-disclosure. The self-disclosure by the age is disclosed by the person concerned. And the third one is the by way, like the biometric thing we can go for. But still, all these three, whether it is a self-disclosure, the age is disclosed by the person, or through the ID verification, or through the biometric verification, all three are still is not settled principle to be followed by the data fiduciary. Still, we need to have a clarity. And once I was listening privacy nama discussion on the 26th and 28th, 26th and 27th October of this year, where the Binyanama House is talking about this concern, and this says that we need to upgrade this concern. We need to discuss this concern up to the war front, and we need to aware the people regarding the concern of consent related to child at the very grassroots level. Then only this aspect of consent can be addressed in a proper manner. So thank you. This is all from my part. Due to the paucity of time, I will not able to cover rest of the question, but you may send me all the questions through the organizers, and I will try my best to give you the quality answers through mail. So thank you all. Over to you, Ayush.
Thank you so much, sir. Participants, if you have any question, please drop down in the chat box.
Now I may leave. I think so. Thank you, sir, once again, and thank you, Nisanji. Thank you all the participants and all organizers.
Thank you, sir.
Thank you so much, sir. Participants, if you have any question, please raise hand or write in the chat box. Questions addressed to Gaurav sir and Honorable Vice Chancellor sir, you can send us and we will collate and send them individually. Nishan sir, there is a question for you. Can the Indian judiciary be completely digitalized and use AI?
It's judiciary can be digitalized in a successive manner. It also depends upon state judiciary. State judiciary, I mean to say from High Court. If High Court give any direction to district courts or uh, other forums, then it can be done so. It's not only responsibility of Supreme Court to direct all High Court or district courts to implement AI. It's also responsibility of respective high courts also. It's also about it's there is also difficulty of funds in digitalization of court records or VC proceedings. So if a state government provides funds, then it may be possible. There is also willpower. If a state government, if a high court or a state government mutually decide to that it will, then it can be possible. It also needs participation of bar. If bar does that they will not attend virtually, they then it creates problem also. It's not only possible for Supreme Court or any of the member of bench that if they give any direction and to mm, that all the digitalization of courts, then it is not only possible from the viewpoint of bench. Bar also needs to it also needs participation of bench, bar, and also public also. If public do not take part in virtual proceedings, then it will create problem. Evidence cannot be recorded through virtual mode. It needs physical participation of clients or litigant. So it will take time. It's a gradual process.
Well, sir, thank you so much.
Mm.
Asika, is this question for Gaurav sir? Can you please confirm? Great, we'll mail him. Questions, please, when you address to VC sir and Mr. Kumar Gaurav sir, you please write us on a mail articles@tscld.com. I write it here, and we will collect all those questions and send them to the respective speakers. Thank you, Vaidehi. I don't think we have much questions. Gurdeep, please address your question to articles@tscld.com. We'll compile all those questions individually and we'll send them. And you will hear a response whenever we hear a response from the concerned speaker. Thank you. Over to you, Isita. Okay, please. No, please. You, Gurdeep. Gurdeep and others, whosoever has a query regarding query and you are addressing it to Gaurav sir and VC sir, please address it to articles@tscld.com. We'll send them. Over to you, Isita.
Thank you, Ayush, for conducting a very smooth Q&A session. As we draw the curtains on this enlightening webinar, I am filled with gratitude for the invaluable insights shared by our distinguished speakers today. The discussion on constitutional law in the digital age have been nothing short of illuminating, offering a comprehensive exploration of the challenges and opportunities that lie at the intersection of law and technology. Our esteemed speakers, Honorable Vice Chancellor Sir, Professor Yogesh Pratap Singh, Mr. Kumar Gaurav sir, and Advocate Nishant Verma sir, have not only enriched our understanding of the subject matter, but have also provided us with a roadmap for navigating the complex legal landscapes of the digital era. Their depth of knowledge, coupled with practical experiences, has undoubtedly left an indelible mark on our intellectual pursuits. On behalf of the NSS cell of CNLU and the Society for Constitutional Law Discussion, I extend my heartfelt gratitude to the esteemed speakers for gracing us with their presence and sharing their profound insights. A special thanks to Mr. Kumar Gaurav Sir, Program Officer of NSS cell CNLU Patna. Thank you so much for your constant support, sir. Without your support and the support of the team at TSLD, this webinar would not have been possible to organize. I would also like to extend my heartfelt appreciation to all the participants for your active engagement and thoughtful contributions. It is your enthusiasm and curiosity that have made this webinar a truly collaborative and enriching experience. Your insights are valuable to us, and we encourage you to share your thoughts through our feedback form. This form is designed to gather your opinions on various aspects of the webinar. It will be posted in the chat box. This form will play a crucial role in enhancing the quality of our future events. Please take a moment to fill out the feedback form accurately. Additionally, the e-certificates for your participation will be issued based on the information provided in this form, so kindly ensure the details are correct. A special word of thanks to the organizing committee, volunteers, and technical support team for their tireless efforts in ensuring the smooth conduct of this webinar. Your dedication behind the scenes has not gone unnoticed, and it has played a crucial role in the success of this event. As we move forward, let us carry the torch of knowledge ignited today and continue to explore, question, and adapt to the evolving facets of constitutional law. The digital age presents challenges, but it also opens doors to innovation and progress. Let us, as legal scholars, practitioners, and students, embrace the opportunities that lie ahead and contribute to shaping a legal landscape that aligns with the spirit of our Constitution. Once again, thank you all for being a part of this intellectually stimulating journey. Let us carry this knowledge gained today forward and continue to engage in meaningful dialogues that contribute to the advancement of constitutional understanding in our digital age. Thank you, and we look forward to welcoming you to future events organized by NSS Cell, CNLU, and the Society for Constitutional Law Discussion. I wish you again a very happy Constitutional Day and also wishing you all a great day ahead.
Thank you, Ishita, and thank you, Ayush. Thank you, sir, for inviting me.
Thank you so much, sir. Thank you so much, Ishita. Thank you so much, everyone who joined. Let us end the session, and please make sure that you fill the feedback form. Thank you.
If there be any question, I shall answer happily on mail.
Sure thing, sir. Thank you so much, sir, once again.
Thank you, Ayush.